Title 12. Deposit. Chapter 2. Voluntary deposit. Section 1. General provisions. Article 1968. A voluntary deposit is that wherein the delivery is made by the will of the depositor. A deposit may also be made by two or more persons, each of whom believes himself entitled to the thing deposited, with a third person, who shall deliver it in a proper case to the one to whom it belongs. Article 1969. A contract of deposit may be entered into orally or in writing. Article 1970. If a person having capacity to contract accepts a deposit made by one who is incapacitated, the former shall be subject to all the obligations of a depository, and may be compelled to return the thing by the guardian, or administrator, of the person who made the deposit, or by the latter himself if he should acquire capacity. Article 1971. If the deposit has been made by a capacitated person with another who is not, the depositor shall only have an action to recover the thing deposited while it is still in the possession of the depository, or to compel the latter to pay him the amount by which he may have enriched or benefited himself with the thing or its price. However, if a third person who acquired the thing acted in bad faith, the depositor may bring an action against him for its recovery. Section 2. Obligations of the depository. Article 1972. The depository is obliged to keep the thing safely and to return it, when required, to the depositor, or to his heirs and successors, or to the person who may have been designated in the contract. His responsibility, with regard to the safekeeping and the loss of the thing, shall be governed by the provisions of Title I of this book. If the deposit is gratuitous, this fact shall be taken into account in determining the degree of care that the depository must observe. Article 1973. Unless there is a stipulation to the contrary, the depository cannot deposit the thing with a third person. If deposit with a third person is allowed, the depository is liable for the loss if he deposited the thing with a person who is manifestly careless or unfit. The depository is responsible for the negligence of his employees. Article 1974. The depository may change the way of the deposit if under the circumstances he may reasonably presume that the depositor would consent to the change if he knew of the facts of the situation. However, before the depository may make such change, he shall notify the depositor thereof and wait for his decision, unless delay would cause danger. Article 1975. The depository holding certificates, bonds, securities or instruments which earn interest shall be bound to collect the latter when it becomes due, and to take such steps as may be necessary in order that the securities may preserve their value and the rights corresponding to them according to law. The above provision shall not apply to contracts for the rent of safety deposit boxes. Article 1976. Unless there is a stipulation to the contrary, the depository may commingle grain or other articles of the same kind and quality, in which case the various depositors shall own or have a proportionate interest in the mass. Article 1977. The depository cannot make use of the thing deposited without the express permission of the depositor. Otherwise, he shall be liable for damages. However, when the preservation of the thing deposited requires its use, it must be used but only for that purpose. Article 1978. When the depository has permission to use the thing deposited, the contract loses the concept of a deposit and becomes a loan or comodatum, except where safekeeping is still the principal purpose of the contract. The permission shall not be presumed, and its existence must be proved. Article 1979. The depository is liable for the loss of the thing through a fortuitous event. 1. If it is so stipulated. 2. If he uses the thing without the depositor's permission. 3. If he delays its return. 4. If he allows others to use it, even though he himself may have been authorized to use the same. Article 1980. Fixed, savings, and current deposits of money in banks and similar institutions shall be governed by the provisions concerning simple loan. Article 1981. When the thing deposited is delivered closed and sealed, the depository must return it in the same condition, and he shall be liable for damages should the seal or lock be broken through his fault. Fault on the part of the depository is presumed, unless there is proof to the contrary. As regards the value of the thing deposited, the statement of the depositor shall be accepted, when the forcible opening is imputable to the depository, should there be no proof to the contrary. However, the courts may pass upon the credibility of the depositor with respect to the value claimed by him. When the seal or lock is broken, with or without the depository's fault, he shall keep the secret of the deposit. Article 1982. When it becomes necessary to open a locked box or receptacle, the depository is presumed authorized to do so, if the key has been delivered to him, or when the instructions of the depositor as regards the deposit cannot be executed without opening the box or receptacle. Article 1983. The thing deposited shall be returned with all its products, accessories and accessions. Should the deposit consist of money, the provisions relative to agents in Article 1896 shall be applied to the depository. Article 1984. The depository cannot demand that the depositor prove his ownership of the thing deposited. Nevertheless, should he discover that the thing has been stolen and who its true owner is, he must advise the latter of the deposit. If the owner, in spite of such information, does not claim it within the period of 1 month, the depository shall be relieved of all responsibility by returning the thing deposited to the depositor. If the depository has reasonable grounds to believe that the thing has not been lawfully acquired by the depositor, the former may return the same. Article 1985. When there are 2 or more depositors, if they are not solidary, and the thing admits of division, each one cannot demand more than his share. When there is solidarity or the thing does not admit of division, the provisions of Articles 1212 and 1214 shall govern. However, if there is a stipulation that the thing should be returned to one of the depositors, the depository shall return it only to the person designated. Article 1986. If the depositor should lose his capacity to contract after having made the deposit, the thing cannot be returned except to the persons who may have the administration of his property and rights. Article 1987. If at the time the deposit was made a place was designated for the return of the thing, the depository must take the thing deposited to such place, but the expenses for transportation shall be borne by the depositor. If no place has been designated for the return, it shall be made where the thing deposited may be, even if it should not be the same place where the deposit was made, provided that there was no malice on the part of the depository. Article 1988. The thing deposited must be returned to the depositor upon demand, even though a specified period or time for such return may have been fixed. This provision shall not apply when the thing is judicially attached while in the depository's possession, or should he have been notified of the opposition of a third person to the return or the removal of the thing deposited. In these cases, the depository must immediately inform the depositor of the attachment or opposition. Article 1989. Unless the deposit is for a valuable consideration, the depository who may have justifiable reasons for not keeping the thing deposited may, even before the time designated, return it to the depositor, and if the latter should refuse to receive it, the depository may secure its consignation from the court. Article 1990. If the depository by force majeure or government order loses the thing and receives money or another thing in its place, he shall deliver the sum or other thing to the depositor. Article 1991. The depositor's heir who in good faith may have sold the thing which he did not know was deposited, shall only be bound to return the price he may have received or to assign his right of action against the buyer in case the price has not been paid him. Section 3. Obligations of the depositor. Article 1992. If the deposit is gratuitous, the depositor is obliged to reimburse the depository for the expenses he may have incurred for the preservation of the thing deposited. Article 1993. The depositor shall reimburse the depository for any loss arising from the character of the thing deposited, unless at the time of the constitution of the deposit the former was not aware of, or was not expected to know the dangerous character of the thing, or unless he notified the depository of the same, or the latter was aware of it without advice from the depositor. Article 1994. The depository may retain the thing in pledge until the full payment of what may be due him by reason of the deposit. Article 1995. A deposit is extinguished. 1. Upon the loss or destruction of the thing deposited. 2. In case of a gratuitous deposit, upon the death of either the depositor or the depository.